Seth Stern, co-author of Justice Brennan, Liberal Champion.
And Steve Wermiel, the other co-author of Justice Brennan, Liberal Champion.
There's this famous anecdote that asked, did you make any mistakes as president, President Eisenhower, that he responded yes to, and they're both sitting on the Supreme Court, referring to Brennan and Warren. Steve's research suggests that it's a great anecdote, but it's not necessarily true, that he probably didn't say it, certainly didn't say it publicly. He may have thought it. I mean, Warren and Brennan certainly were more have wanted. On the other hand, as we talked about, the criteria, based on the criteria that he had laid out in September of 1956 on the eve of re-election, Brennan suited those purposes. And whether he was more ideologically liberal than Eisenhower had predicted, absolutely, but that wasn't the reason that he picked him to begin with. As for his Attorney General, I think Brownell was a moderate Republican, and I don't necessarily think that if he did read all of his opinions and did see some of the kernels of the future Justice Brennan, he didn't have a problem with it.
I mean, I don't think Souter would either does or would describe himself as reflecting the same set of values or vision of the role of the court. They became good friends. They were both very solicitous of one another. It was a very important relationship to Brennan after he retired, because Souter would come take him to the judge's dining room when the justices were gathering for lunch once in a while, and Souter would come have a cup of coffee with him once in a while, and I think that made a big difference to Brennan. There's a public sort of image or characterization of Souter as having fallen under Brennan's spell. This is a notion that conservatives have been selling for 20 years, and I really think it's not true, and I know Souter thinks it's not true because we've talked to him about it at some length. I think Souter, as an old-fashioned conservative with a small c, came to the court with an enormous respect for the history and precedents of the court. And if you arrived at the Supreme Court in 1990 and took precedent seriously, that meant taking Brennan seriously. I mean, that's part of the whole point of the book, is that Brennan left a fairly broad landscape of legal landmarks, and Souter, I think, was very respectful of many of those precedents and saw Rehnquist and the other wing of the court as kind of devoted to knocking down many of those precedents and landmarks, and that wasn't where Souter wanted to be. I don't know that there really was. He had enormous respect for many of his colleagues. He in an interesting sort of way, and this will sound odd, but I'm tempted to say John Harlan. He respected Harlan and Harlan's open-mindedness. I mean, Harlan often came out opposite of Brennan and was clearly more conservative than liberal, but I think Brennan always felt that he could talk to Harlan, that he could approach Harlan, that Harlan really thought things through and wasn't caught up in some kind of dogmatic ideological track, and so I think Brennan respected that enormously, and he talked a lot about Harlan, the time that Harlan spent in dissent, and how patient and understanding Harlan was. And Brennan would talk about the pendulum swinging, as in Brennan's own time, as the court got more conservative, he would say, now I understand how John Harlan felt when he was in dissent all those years, but I do believe that the pendulum will swing back. So, I don't think Harlan was a role model, but I think he had enormous respect for Harlan's decision making.
I don't think it was unique. I think he had respect for, as you said, Rehnquist, for Antonin Scalia, for many of the justices he disagreed with. He thought they were very bright and was impressed by the work they did. I don't think that's unique. You could look on the current court. Ruth Bader Ginsburg and Antonin Scalia are close friends. They don't agree about much, so I don't think that was uniquely Brennan. But the other aspect that you referenced, the contrast between Brennan, the liberal justice, and the more conservative man, is a fascinating theme that we developed throughout the book on issues like abortion, where he was he helped lay down the privacy right and a series of precedents, and then helped craft the Roe versus Wade abortion decision, and yet was personally uncomfortable about abortion, as he revealed to Steve. Freedom of the press, he was a champion of the free press, and yet he distrusted reporters, would sort of rail against them, curse about them in his interviews with Steve, and most strikingly on women's rights, where he was the champion of women's rights and wrote many of the landmark women's rights decisions in the 70s, and yet would refuse to hire female clerks well into the 70s when they were recommended by his former clerks who are now law professors. So it's a central theme, and getting at that, I think part of it is there's the conservative critique that liberals just are reading their own personal preferences into the Constitution, and I think Justice Brennan proves that that's not true. He wasn't just injecting his own personal preferences when he was writing opinions. He separated what he believed personally from how he approached his job as a justice.
So
set apart certainly from his personal views.
I do also think, in response to your question, though, that there were times when he had this kind of odd, almost overarching institutional sense that he could, he could look at me and say, didn't Rehnquist do a marvelous job in that opinion, in which Rehnquist had just, knocked Brennan out of the ballpark with some decision, almost in the sense of like an old-fashioned military strategist who doesn't want to lose, but who admires the strategy of the winning general with some detachment when he does lose. There were times when you saw that in Brennan. I do remember this moment in one of the interviews where I talked to him about a Rehnquist opinion that was a very conservative opinion. I don't remember what it was, and said something about how did he feel about Rehnquist winning that case, and Brennan said, "Oh, wasn't he marvelous?" Like this sort of detached appreciation that he liked his colleagues, and he also cared about the court having majorities and not being fractured, and so he could sort of have this out-of-body appreciation of Rehnquist winning this case, even if it was at Brennan's own expense.
I think
You could look at it, certainly he inherited certain political skills from his father, who was a very beloved and popular city commissioner in Newark, New Jersey. We strongly make the point that his success wasn't because he was some skilled retail politician working the halls, but he learned, I think, the art of politics from his father. I think he was he was a corporate labor lawyer in Newark. That's where he spent most of his career, and he learned the art of negotiation there, and then in the Army when he was helping mediate serious labor disputes during the war. So he did bring a certain skill set to the court, and it served him very well. On the other hand, another important component of that success was the fact that he served in an era when there were moderate centrists willing to be persuaded. Justice Harlan, Justice Lewis Powell, in the 70s, Harry Blackmun and John Paul Stevens. We make the point in the book that he could, someone on the current court could be as skilled as he was as a consensus builder, but if you're serving on a highly fractured, ideologically divided court, or say if he was serving on a court with 8 Antonin Scalias, there would be no room for even a Brennan-like consensus builder to build much consensus.
I think there are plenty of places where Brennan fudges the origins of tests and standards, or rewords something in order to hold on to a fifth vote. I was just teaching the gender discrimination cases in the constitutional law class, and when Brennan arrives at the standard he eventually uses for gender discrimination, called intermediate scrutiny, the paragraph says, "Our cases establish." Well, that's utter nonsense. There are no cases that establish. This is the case in which he's making up the test. So there are moments like that where the court is sort of hedging a little bit and tinkering a little bit here and there, and I think Brennan thought that was necessary and kind of part of the process.
And there were times when, in order to build a majority, or to build instead of a 5-4, go up to 6-3 or 7-2, things would get a little muddled in bringing people on board, and so his opinions weren't always models of clarity. There were two school prayer decisions in the early 1960s, one in which he was building one of those sort of group opinions, and then the other where he was concurring in his own voice, and the newspapers the next day noted the contrast, where really the one that was in his own voice was so much more clear than the one that was a group product and an effort to build consensus.
He believed, there's an interesting, I don't know that it's really a contradiction. He believed that the court had an obligation to try to speak with clarity, and that it was all about getting 5 votes, and not, he disliked fractured and deeply divided courts. That didn't mean he didn't participate in more than his fair share of them when necessary, but I think he was trying often for clarity and a clear bottom line. Whether he could succeed or not would often depend on the willingness of a fifth vote to go so far or how far. But I think that didn't mean Brennan wasn't striving for a clear result and a clear message. He didn't always get there.